Constitutional Court has dismissed former President Jacob Zuma's application to rescind his 15-month sentence for contempt of court. Right, let's get some reaction on the Constitutional Court ruling. I'm joined now by legal expert Mpumelelo Zikalala. Mpumelelo, very good morning to you. The rescission bid has been denied. Was this one that was expected?
I think, judging from the way in which the justices dealt with the questions or were posing questions to the parties, one would have had an idea that they were sort of swinging towards denying the application of the former president. But on the basis that on the two most important factors, the definition of absence, and in this case being defined as a voluntary absence, in which they are saying you were given an opportunity and you are the one who chose to deliberately not to participate in it, while being fully aware of what was happening. One would quote the instance of the multiple page letter that was written to the ConCourt's. And the other one saying that according to the law, there's no error of law that has occurred in this case. So they're basically saying, using Rule 42 read with Rule 29 of the ConCourt rules, there's no basis in order for us to make this particular decision.
So effectively, Mpumelelo, in reading Rule 42, which talks about a court having the right to vary or rescind a ruling granted in the absence of an affected party, in effect, does this ruling then expand or rather define the meaning of absence?
Yes, definitely it does, because it then says the absence in this case, we are referring to, firstly, the knowledge that there's a particular matter going on which involves you as a litigant, in which you are required to come and give evidence or provide a defense on. The second one is the physical sort of appearance of saying that you know that on this particular date there's a matter which is going to be dealt with, in which you are the litigant and in which you must respond into the allegation that's been leveled against you. If you fail to attend to those, being well aware that these proceedings are continuing, then the court is well entitled to say, you voluntarily agreed not to participate. So if you haven't participated, we are going to take an appropriate order, taking into account that we are aware that these decisions was going to be taken, and you simply said, I will abide with whatever decision that you are going to come up with.
Now, as a layman, we always understand international law to be effective or to override local laws, basically, or local matters. But the court here is saying that the South African courts are not bound by international law in this respect. Is that how we've always understood it, or does it matter, does it differ from a case to case?
I think in this case the court may have been mistaken in the following sense. When it comes to international law, you find the most basic and grounding principles in terms of our law. So, for example, when it comes to access to justice, when it comes to legal representation, those would form the core or basis of the proceedings that must happen in any court. Now, for you to deviate from that and simply say, I'm simply acknowledging those basic principles out of respect, I'm not really bound by them. It would make a bit of a mockery of the provisions which are written down in our constitution that says that our judiciary is going to recognize international law. Now, in this case, what the court could have said is to say, we have looked at the international law principles. If the core basis of those principles, the intention of those principles, have been satisfied in this case, due to that, you as the former president were given an opportunity to come and present your case. You were given an opportunity to go to a legal representative and say to them, I want to go and defend myself. You could have even came yourself without being represented, and you could have heard you. But you deliberately chose not to attend to those proceedings. And it is only now, when we are sending you to jail, in which you've understood the seriously of this matter, and you now understand the impact of this matter, and now you want to come and stage your case at this late stage. We can't have that as this court, because the principle of finality is important, and we must be seen to make sure at all times that we are able to discuss matters and at the end of the day take a decision and bring them to finality.
As the majority spoke about how they're disputing the ICCPR with this matter, a mention of Parliament, a parliamentary decision, was also mentioned in this international law argument. What role could Parliament's decision have played when it comes to the amendments to this international law aspect?
Let's remember that whenever we are going to be part of any treaty, Parliament will have to ratify that particular decision and agree and say, yes, us as South Africa, we're going to be part of this international treaty. Now, the role of Parliament in this case, it would be to say, let us check with the the principles that are applicable when it comes to South African law. Are they in conflict, or are they in line with the proposed international law or international treaty that you want to subscribe to? If they aren't, then we can agree and say we're in sync, we're happy. Let's go and sign the treaty. It's going to apply to us. But the most basic of the test that is used when these type of applications are being done is then to say the current principles that we have compared to the ultimate notion of justice. Can a person be heard? How are we going to put in impediments in which are going to cause people not to be able to access the courts at the appropriate time? Are there going to be adverse decisions which are going to be taken when they don't even know that they're supposed to be at court? If the answer to that is no, and if the doors of justice are open, if the doors of the courts are open in order for one to participate, then the Parliament will then say, let's go and sign the treaty and let's be part of it.
Very well. Thank you so much for weighing in on this discussion, legal expert Mpumelelo Zikalala.